So, gagging orders, should they be banned, or are they actually really good, and how do you go about getting one? Well, recently in the news we've seen a scandal involving Sir Philip Green, whereby a number of his ex-employees have come forward and said that he's either sexually harassed them, specifically groping women in his employ, or for example racially abusing them, an instance where he's alleged to have told a black man to have go throw spears in the jungle. Now, he's gone ahead and got them to sign these kind of gagging orders at the time. Now this story is breaking. The question is, have we seen too many gagging orders in public life, and are they actually stifling the truth? And what should we do about gagging orders? So, what exactly is a gagging order, and why would you want one? So, when people talk about gagging orders, what they're usually referring to at the moment in the media is something which is a confidentiality clause within a settlement agreement document. That document is something that you would sign as an employee if you're leaving your job after you've been treated badly and you want to accept a sum of money to kind of leave quietly and not go to court or not make the allegations public. Now, these allegations that settlement agreements could cover, do include things like sexual harassment or racism, and more commonly things like unfair dismissal or constructive dismissal or breach of contract, which are the more run-of-the-mill cases that you're more likely to see more often. Why would you want one? Well, actually, for an employee to go to court to resolve their dispute with the employer is often a very long and expensive and frankly stressful process. There's plenty of risk involved of losing the case. A lot of these types of allegations are very difficult to prove. So things like sexual harassment and racism, often they'll be done when there are no witnesses, and so you've got no one present to kind of back you up in court. And often it won't be done in emails, so it won't be in writing. So how are you going to prove that in court? You're very likely to find that you're going to potentially lose that case, or in order to win, you would need expensive lawyers, to represent you for could be weeks or months or years before you even win a case. So a lot of people would actually prefer to receive a lump sum payment and kind of move on with their life. Then you've got the money in the bank, you've got certainty about your future. You don't have to spend another year or two of stress kind of reliving whatever happened to you over and over again, and with the chance of walking away with nothing. So actually, these confidentiality clauses in settlement agreements, or gagging orders as they've been called, are actually a kind of a great thing for a lot of people. People who just want to move on with their life. They accept that they can't change what happened in the past. Yes, they've been treated badly and they wish that never happened, but you can't turn back the clock. So what you can do is you can get financial compensation for that. So in a way, you might think yourself lucky to receive a decent sum of money and be able to move on with your life in a kind of a quiet way. Right, if you later change your mind and you want to go public with your allegations, what can you do about it if you've signed a gagging order? Actually, there's not a lot you can do about it without the risk of being sued by your ex-employer or by the old boss or whoever it was that got the settlement agreement signed off with you. The reason for this is that you've accepted a sum of money in exchange for keeping quiet about what happened. So that was a kind of a contract that you entered into freely. So yeah, in court, a judge would probably say that you'd have to pay that money back if you then went and changed your mind in the future. You went against what your decision was and you decided to go public, you'd have to pay the money back. And if you were kind of being sued about this whole thing, you could end up paying a lot of money in legal fees too. Now, in order to protect you as an employee, one protection in place is that in order to be legally binding, a settlement agreement has to be countersigned by your lawyer. So you have to get an independent lawyer, such as us here at Monaco Solicitors, for example, to put a third signature on that document. And we would advise you about your rights, the financial compensation that you might be able to get in a court case, whether this is a good deal financially. We understand, as I said before, you can't turn back the clock, but is this money kind of enough to reflect what happened to you? So kind of a bit of a silver lining to this cloud. And once you're happy that you're sure about your rights and you know what you're doing, you're sure you want to accept the deal and take the money, then you would sign it off, and we or your lawyer would sign it off and it would become legally binding. So yeah, it's difficult to go back on that in the future. What these settlement agreements don't do is they don't prevent you from going to the police or to a regulator. So you can always do that after the event. So if a crime's been committed, a gagging order can't actually stop you from getting justice. But what they do stop you from doing is going to the press, by and large, or talking about it to friends, to colleagues, on social media. So there's a big distinction there. So what effect has the recent media storm about Philip Green had on the future of gagging orders? Well, we've seen politicians talking about banning them. As usual, politicians are talking about things in a way of reacting to public opinion here, and they're not on a very well-informed basis. So yes, it's great that unscrupulous employers are being exposed, and it's great that people like Sir Philip Green are being called out for totally unacceptable behaviour. That's brilliant, but let's not throw the baby out with the bathwater here, because actually these confidentiality clauses, these gagging orders, as I said, are great for employees who just want to move on with their lives. If you ban them, what are you going to do as an alternative? What is that employee? What are their options going to be? Will they have to fight this thing in court and only be able to get compensation from a judge? Because in my experience, most employers just wouldn't do that. They don't want to be this public figure, this martyr for the cause to bring down the billionaire tycoon. They just want to move on with their lives. So if you take away their one mechanism for a quick settlement where they can kind of move on, what are you going to replace it with? They don't want the stigma going to a next job. They don't want to be that person in the interview, who went public against their old employer. They just want to accept some money and agree not to talk about it anymore. Now, in fact, in my book, The Resignation Revolution, I'm talking about how to get yourself a settlement agreement and how to get paid off when you've been badly treated at work. So rather than just resigning and crying into your cornflakes and having a bad time and being down on your luck and a real confidence blow, get some money from your old employer, get a severance package, get a payout, and then you can move on with your head held high, knowing that you were in the right and you got fairly compensated for it. So, how do you go about getting yourself a settlement agreement with a confidentiality clause if something really unfortunate has happened to you at work? Well, first of all, get yourself a good lawyer. But if you can't do that and you want to do it yourself, there's a couple of things we would advise. Firstly, try and keep it verbal. So try and keep it out of writing. Rather than committing into writing your complaint, like for example in a grievance, you would want to maybe have a phone call, a without prejudice phone call, which is an off-the-record chat where you're telling HR or telling your boss's boss or someone high up in your employer what's happened. But as soon as you put it into a formal written grievance, then this could trigger a whole investigation. Your employer would have to finance that. They'll be trying to prove their person innocent most of the time, so they'd be spending loads of money on this kind of investigation when in fact they could be paying you that money. So try a verbal approach first, try an off-the-record without prejudice phone call, or even a without prejudice letter if a phone call doesn't work, and only then really kind of decide to commit it into writing in an open basis if you don't get anywhere, and court is a last resort. But a lot of times, companies don't want these kinds of allegations coming out, so if there is a bit of evidence that you can bring into the spotlight, whether that's verbally, for example, then you have got a good chance at negotiating yourself a deal and just be able to move on with your life. Thanks very much.